And welcome to the Pulse. It is still our continuing coverage of the election petition hearing. We need to go back to the court right now to hear the lawyers of the sides involved in this case speak. As you can see, that those are live visuals coming to you. The lawyers getting ready to speak. The lawyers for President Nana Addo Dankwa Akufo-Addo, who is the second respondent in this case. Let's go over there right now.
They're ready.
Are they? Yes. Good afternoon, ladies and gentlemen of the press, and by extension, the entire Ghanaian public. After a long day in court, the justices of the Supreme Court have had to adjourn the proceedings of today to Monday, the 1st of February 2021, to enable second respondents team play a video which was annexed to the witness statement. You all saw the proceedings in court through the morning to this late afternoon. We started by the second respondent objecting to offending paragraphs in the witness statement of Johnson Asiedu Nketia, the General Secretary of the National Democratic Congress, on whose ticket the petitioner John Dramani Mahama stood as his presidential candidate to contest the December 7, 2020 elections. Out of 10 offending paragraphs, the court graciously admitted 3 of the paragraphs to remain, and 7 of the offending paragraphs were removed in part, but 1 of them was totally expunged from the witness statement. It is pertinent to state that 1 of the offending paragraphs related to the pedestrian allegation of Asiedu Nketia in his witness statement that the chairperson of the Electoral Commission has a familial relationship with Her Excellency the First Lady of the Republic, Mrs. Rebecca Akufo-Addo. We all witnessed the strenuous and tedious submissions by petitioners' lead counsel to answer to the objections which had been raised to portions of the witness statement.
Repetition.
It was a repetition after repetition, which prompted lead counsel for second respondent, who could not bear it any longer, to remind the court of the petitions, of the repetitions. When Mr. Johnson Asiedu Nketia took to the witness box, he remained largely evasive. Every question that was posed, his immediate response is that, "I do not speak for the petitioner." This is someone who, in paragraph 2 of his witness statement, has stated clearly that he was in court to end or lend aid to the petition filed by petitioner. How can you come to court as a witness for a party and when you are asked questions in court, your response is that I don't speak for the petitioner, then why are you in that court? Why are you then in the court? He thinks he can be as elusive and invasive as he was in 2013. This time around, he will not be lucky. Now, it is very instructive to let all Ghanaians know that the one person who filed the petition, which is John Dramani Mahama, has refused, failed, or neglected to sign onto a witness statement. As we address you this afternoon, the petitioner himself has no witness statement before the court. This is a petitioner who seeks to have the elections annulled and is praying for a rerun. This same person is refusing to come and give evidence in court. The judgment is with the Ghanaian public, not mine. When Johnson Asiedu Nketia went all about town, he said one thing which is poignant. When he was posed the question by a lawyer for first respondent, his response was that we are in court to challenge the conduct and constitutional duty of first respondent. We are not in court to challenge the elections. I mean, that is Johnson Asiedu Nketia's own statement, not mine. Instructive. We are in court to challenge the conduct and constitutional duty of first respondent, not the elections. So this is where we are. As I always do, I will allow you to ask questions, if any.
First question. Can you repeat your question again?
I'm saying that the latter part of the proceedings, you will repeat the question. Otherwise, they won't. Was not relevant to the case, meaning that the substantive matter that is before the court is the claim that no one can bother with the decision of the Court Council, not the claim that no one won, someone won and bother with the decision.
In court, the test for every witness in court is the witness's credibility. So you realize that when we went on and on and on, the final leg of the submission was that we want to attack the credibility of the witness. And it was at that point that the court was minded to grant the application for a play of that video. Now the relevance, to you it might not be relevant, but the relevance is that these are persons who, after or during the course of the elections, had proclaimed to Ghanaians. In fact, the presidential candidate himself, John Dramani Mahama, the General Secretary, Johnson Asiedu Nketia, the Deputy General Secretary, Utokuno,
And the rest.
the Director of Elections, Evisafi Ankra, and their communication officer, Sami Jemfi, had proclaimed to the whole of Ghana and the world that their presidential candidate had won the presidential elections and they had secured, some were saying 140 seats in parliament, others were saying 141, others were mentioned that they were not even sure. And when they proclaimed that they had won the presidential elections, they gave you percentages. Don't pretend as if you didn't hear. They gave percentages. And some of them were calling the presidential candidate president-elect. I think I recall, Sami Gemfi, a communication officer, referred to Mahama as the president-elect. Some of them even urged him to form a parallel government. Now when they are being invited to the police, there's another story. They advised him to run a parallel government because they had won the elections. Now these are the same South people who now, when come to court, cannot even tell how many votes they garnered and are asking for a rerun. Does that sit well with you? And you think it sits well with Ghanaians? No. But you see, I must point out also that the exhibit that Asiedun Ketia was confronted with was their own exhibit. The exhibit E. It was their own exhibit. In his testimony, they failed to sign on to regions where it was abundantly clear that the petitioner had won elections there. Their agents in the strong room decided to take a long jump when they realized that the results proved unfavorable in their cause. That is my answer. Have you read paragraph 2 of his witness statement? Maybe if you read paragraph 2 closely, on Monday when I come, we can have that engagement. But when somebody says that the petitioner stood on the ticket of the National Democratic Congress to contest the elections, and I, the General Secretary, the Chief Executive Officer of the party, I am swearing to a witness statement to give evidence in support of the petition filed by the petitioner. Would you still want to maintain your question?
Well, I just want to know the difference between when someone says, I am not the petitioner, and I do not speak.
A witness only corroborates the case of the party. You don't become a witness in court because you have sprung up from somewhere, maybe from Mountain Kilimanjaro. You become a witness because there is a necessary party in the case. John Dramani Mahama has not donated a power of attorney to anyone to speak on his behalf. It is Johnson Asiedun Ketia and Dr. Kwesa White who are coming to speak as witnesses. And they all state that they are speaking in support of the petition. So you cannot come to court and lend aid to a petition, and when you are asked questions in court, you say, I am not a petitioner. So what are you? Are they aware of someone?
Okay, thank you very much.
I would end, as I always do. If you have nothing to say about another person, whether that thing is useful or beneficial, then please do not say anything at all. Because if you invariably say what you want to say, you will prompt the other person to also say something or respond in a way or manner that may or may not just otherwise be pleasant to you. Let's all be guided by fidelity to the truth and don't bear false testimony. Thank you.
But your chief for the trying lawyer upon now on Casas here. Lawyer.
Okay. You remember the tougher? Near Ohoni say Emre Musaudi Asemuba Kota.
Well, you're still watching our continuing coverage of the election petition hearing, the substantive hearing of which started today with Johnson Asiedu Nketia, the NDC's General Secretary, in the witness box. And of course, you had the updates there from Godfred Yeboah-Dame, who is the Attorney General designate. Well, he's yet to be approved. Well, he talks about what happened in court today, essentially who came into the witness box, which is Frank Davis, I beg your pardon, who was speaking there. Well, he talks about the at least 10 paragraphs in the witness statement of Johnson Asiedu Nketia that they had issues with, and which lawyer Kotampao, of course, raised in court. And he talked about the fact that the judges seem to have agreed with them largely, because out of the 10 paragraphs that they had issues with, the court admitted only 3 and removed 7. In fact, he says 1 was completely expunged from the witness statement, the one which borders on familial relations between the first respondent, which is the Electoral Commission, and the wife of Nana Addo Akufo-Addo, the president, who is also the second respondent. So he talked about the fact that had been expunged completely from the witness statement. But he commented on Mr. Asiedu Nketia's conduct in the box, and he says he was largely evasive. He did not. He indicated that he did not speak for the petitioner, but then he refers to paragraph 2 of Mr. Asiedu Nketia's witness statement, which he said is a clear statement that supports the fact that he is there to back the petitioner in this particular case, and so he doesn't see the correlation between stating in part of your witness statement that you are here to back a petitioner, and when you are questioned, you indicate that you do not speak for the petitioner. He believes that Mr. Asiedu Nketia was largely evasive. He also talked about John Mahama himself, who is the petitioner in this case, and said that Mr. Mahama has refused, in fact, he used these 3 words, has failed, neglected, and refused to sign a witness statement. So the person who is petitioning, he says, has decided not to be a witness in this particular case. And yet the person who is supposed to be his witness has said that he does not speak for the witness. And of course, you can have a very legal debate about what this looks like and what it even means and what the implications are. He says that Mr. Asiedu Nketia himself, before they came to court, had indicated that they are not in court to challenge the elections, but that they were in court to challenge the constitutional conduct of the first respondent, who is Madame Jean Mensah, who is the chairperson of the Electoral Commission. And he believes that Mr. Asiedu Nketia seems to be diverting from the initial case that he had made outside. He talked about the fact that they had wanted to attack the witnesses' credibility, which is why they asked to play a video. We'll get back to this one, which essentially wraps it up. Let's go to the court again, where Dr. Dominic Ayeni is responding.
Today was very eventful. And I'm sure when you watch the proceedings, you came up with the impression that the John Mahama team brought a solid case to the Supreme Court. In fact, when we filed the petition, it was being bandied about all over the place that our petition was empty, that it had not disclosed a reasonable course of action. Well, today was your answer. I am sure you saw vividly the evidence that was being led by the General Secretary. We have not yet concluded the hearing, and so I will not comment on the merits of what he said. But I'm sure you are all witnesses, and you know that this is not an empty case. Now, let me correct one misrepresentation, very deliberate and gross misrepresentation that lawyer Frank Davis, my very good friend, has made this afternoon. He sought to give the impression that we came to court because we wanted a relief to the effect that His Excellency John Dramani Mahama be declared the winner of the election. I am sure, as ladies and gentlemen of the press, you have read our petition. Nowhere have we sought that relief from the court. What we have sought from the court is very simple and may be summarized in two. First, we want the unconstitutional conduct of Jean Mensah to be held to account. Secondly, we want the court to declare that none of the candidates met the threshold requirements of Article 63, Clause 3 of the Constitution. That is the crux of our case. And that is the case that we have sought to make in court today with the witness statement of the General Secretary of our party. Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013, His Excellency Nana Addo Dankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Addo Dankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change and compel him to testify? I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls. Also, it played out in court today that if we had done proper case management, as we were pushing, we would not be where we were this afternoon. You remember we complained bitterly that case management, as stated in CR 99, was supposed to last 5 days. The court compressed it to 2 days. And in fact told us that we had spent the first day of those 5 days making the case for the interrogatories. Now, it played out in court today. The importance of case management. When they sought to tender the pen drive that contained the so-called videos in which principal officers of the NDC and our presidential candidate made certain statements, you saw what happened. The court was not prepared to play that video because it had not anticipated that it will be needed, and there was no equipment in court for that purpose. As practitioners, we know that at case management, that issue would have come up, and the court would have been prepared that on day one of the trial, a video will be played showing evidence of statements that our principal officers made. Ladies and gentlemen, it is very important for us as a party to underscore the fact that we are not in this case because we want to joke with the Ghanaian people. At the end of the day, the issues of accountability, the issues of the mathematics of Article 63(3), and you very well, you saw it in court. When calculators were flying around, were we the ones who brought the calculators to court? Were we the ones who brought the calculators to court? But we warned you that this case, a big plank of the case, concerns the mathematics of Article 63(4), whether or not Nana Addo Dankwa Akufo-Addo, as a presidential candidate, crossed the constitutional threshold of more than 50% of the vote. Our case is that he did not. And we will prove that in court. Just watch out in the next few days. Any questions?
Counsel, at the start of proceedings, Mr. Sedikit, you have portions of this statement to instructions. I just want to find out whether this has any impact on the case as you have put together.
No, we don't think it has any impact on the case we have put together. We are allowed to bring those matters back, when cross-examining their witnesses. So we don't think that it in any way, destroys our case or minimizes the probative value of whatever evidence we are bringing. But note that they raise the objections based upon the so-called scandalous nature of some of the averments or some of the statements in the witness statement. All right? Now, we had alleged that she acted in a biased manner, in an arbitrary manner, in a capricious manner that was motivated by personal dislike for His Excellency John Dramani Mahama, or if you put it in the converse, her likeness for Nana Addo Dankwa Akufo-Addo, her preference for Nana Akufo-Addo. And that is how come that in our witness statement, we sought to make it abundantly clear that she had a familial connection to the Akufo-Addo family, that she's a relative of Her Excellency Rebecca Akufo-Addo. Now, if that is not material, what is? If you are a family, a relative of the First Lady, are you telling us that you don't want her to continue to be First Lady? So we said that she did it, with a predetermined agenda designed to continue, to let her sister or cousin continue to be the First Lady by announcing that Nana Addo Dankwa Akufo-Addo was the president.
Petitioner himself will not be in the position that he has assigned witnesses to make his case for him. However, in court, at least more than 5 occasions, petitioner's witness declared that he was not the petitioner, and therefore did not answer certain questions.
Well, that's an excellent question. It means that you were watching the proceedings. Let me make it clear that in those instances where the witness said that he was not the petitioner, they wanted the witness to give evidence with respect to the state of mind of the petitioner.
Knowledge.
Okay? Anything attributable to knowledge that is within the personal, knowledge of the petitioner. How do you expect a witness to be able to testify to those matters? And that is how come that he legitimately declined to do so. It is not because he is distancing himself from the petitioner. In fact, he is not here under compulsion. He voluntarily agreed as our General Secretary to testify because he is the chief administrator of the party. He coordinated with the help of the chairman and the other principal officers. He coordinated the election. So who better to testify on our behalf than our General Secretary? And that is precisely what he was doing. But if you insisted that he should speak the mind of the petitioner, he should testify to matters within the knowledge of the petitioner, he would decline. And that was just as it should be. And in law, the General Secretary was right in declining those questions. Any other question? All right. Thank you very much, ladies and gentlemen of the press.
Okay.
And that is the side for the petitioner, John Dramani Mahama, which is also the NDC members that you saw addressing the media. Now, Dr. Dominic Ayine, who is a former Deputy Attorney General himself, is addressing what happened in court today. He talked about the fact that the JM team, which is the John Mahama team, that they came to court with a very solid case against certain misconceptions that he said was that the NDC did not have a strong case. And then he talks about the fact that he would not comment on the merit of what their witness has said today in court. But he wanted to address what he called was a misrepresentation by Frank Davis, who spoke earlier, who is a member of the legal team for Mr. Nana Addo Dankwa Akufo-Addo. And he says that Mr. Frank Davis has been trying to create the impression that their release, the part of the release that they wanted to seek, included declaring John Mahama as winner of the election. He says that is not part of their release. But let's go to court right now. Our court correspondent, Joseph Akable, so that we can have this conversation with him. Hello, Joseph. Joseph, do you hear me? Great. So let's begin with perhaps just.
Yes, I can hear you, Gifty.
Yes, let's begin with perhaps just what has been said, then we can go back to talk about what happened in court, if we must. Both Mr. Frank Davis and Dr. Dominic Ayine raised concerns about what happened in the witness box, and they both have their sides of the story.
I mean, the point that Frank Davis, who is a member of the president's legal team, makes is to the effect that, as far as he is concerned, Mr. Asiedu Nketia was simply evasive and was not forthcoming with information to the court. And he makes reference to portions of his testimony where he was asked questions where he had to answer that he is not a petitioner, at least on more than 2 occasions. Again, he makes the point that there were other questions that were asked about activities involving his various party members, especially relating to how they had conducted themselves post the election in terms of the announcement that they made about the fact that they had won the election. And so the point that he makes in that claim is that this clearly shows that the story that the NDC put out before coming to court is entirely different from what they've come to put before the court. And so that was the point that Mr. Frank Davis also made. And he also questioned why he says the petitioner himself is not signed any witness statements. And a short while ago, you heard Dr. Dominic Ayine respond to that by making the point that the difficulty, making a point that in 2012-2013, Nana Addo Dankwa Akufo-Addo did not testify in that particular matter as well. And so that was the response that came from Mr. Mahama's side. And
Joseph, on the back of that response, we're just getting a little bit of clarification here that actually what happened in 2013 was that we had Dr. Mahmoud Bawumia, who was the running mate for that particular election, who was the petitioner. And that he swore to affidavit and testified for himself and for and on behalf of his co-petitioners, Nana Addo and Jake. So it's not entirely accurate that what is happening here is exactly what happened in 2012.
Well, it is accurate that it is accurate that Nana Addo Dankwa Akufo-Addo did not testify, and that's the point that Dr. Ayine makes. The difference between the 2012-2013 situation and what is happening now is that in the 2012-2013 petition, the rules permitted more than one person to file the case, and so the case was filed by Nana Addo Dankwa Akufo-Addo as first petitioner. It had Dr. Bawumia as the second petitioner, and it also had Jekotanka Obeche-Bilamte also as a petitioner. The current rules, and in this situation now, it has just one petitioner. And so that is the difference by way of the 2 petitions that have been filed. And that is why Dr. Ayine makes the point that the lead petitioner in that matter, the individual who had contested as the presidential candidate, did not testify in court in that instance. And that is his side of the story.
Regarding the fact that Mr. Mahama has not, he says, failed, refused, neglected to sign a witness statement, Dominic Ayine also provides some response there. And also on the back of the issue about whether or not Mr. Asiedu Nketia would be able to speak as though he was the petitioner, he says that what the president's team sought to do was to get him to testify to something that was of personal knowledge to the petitioner, and that it was in Mr. Asiedu Nketia's right to decline to answer those questions.
Yes, and Dr. Ayine explains that the witness is testifying in support of the petition, and more importantly, is testifying on the basis of matters that are in his personal knowledge. And so if he's asked questions that relate to the mental state of the petitioner, then he is obviously not in a position to answer those questions. And that's why he did answer the way he answered. And Dr. Ayine disagrees with the viewpoint expressed by Frank Davis that Mr. Asiedu Nketia was being evasive. He insists that he answered the questions that were within his knowledge, and the ones that were not within his knowledge, he was honest to the court in saying that, look, these are not matters that I can speak directly to because I'm not a petitioner and because you are asking questions that directly relate to the knowledge of the petitioner.
Regarding the video, you asked a question there about the relevance of this particular video. The response was that they were seeking to attack the credibility of the witness, and so it was important for them to play that particular video. But then we also heard Mr. Ayine and their side to it, which is that the courts did not anticipate, and which is why it wasn't heard. Is this not typical of the processes that go on in court?
It's quite typical. In fact, there are other cases that we've covered that the procedure is that there has to be a notification to the court. At a high court, we know that on a daily basis, they tend to have a system in place. Even in that instance, I remember the case involving the NDC National Chairman, Samuel Fosuampofo, when the audio had to be played, the prosecutors had to notify the court, and the court made arrangement to provide those equipment for it to be played. And unfortunately, we don't have a system where we readily have those things available, and nonetheless, you need to prompt the court as well. And so that is what the point they were making, that they had not prompted the court that this will be done. And so eventually, once the request was made and the court granted the request, and the court said that arrangement will be done on Monday. So it means that on Monday, they'll have the opportunity to play that particular video.
Was that an oral application, and would they need any further filing to get this done?
Yes, it was an oral application that they made, indicating to the court that this is something that they want to play. In fact, they had asked for directions from the court specifically about what they wanted to do. And so once the court did indicate through the panel members asking questions that is it a case that they are making a formal application, and once they did indicate that yes, they were making a formal application, so they moved it orally. The comments were taken from Mr. Tashikata, who represents the petitioner John Dramani Ma. Then afterwards, the court said that, it's adjourning proceedings to Monday. So that was how that application was done. It was done orally.
Again, Joseph, the calculator episode, that got a lot of people laughing, actually. But Dr. Dominic Ayine talks about the fact that their case, one of the main things they are in court to do is to get the mathematicals of Article 634. The fact that the threshold wasn't met. Help us understand the whole calculation dynamics and how it became even necessary.
And so the Article 63(4) of the Constitution simply makes the point that in a presidential election, the one who obtains more than 50% of the votes cast, i.e. the 50+1, that person is declared as the president-elect. Now, it is the contention of the opposition NDC and its presidential candidate who has filed this particular petition that the results as declared by the EC chairperson on December 9, you recall she interchanged the total valid votes cast for the total votes cast, which are two different things. She interchanged those figures. Now, their argument is that by interchanging those figures, if you calculate using the figure that she had erroneously announced as the total valid votes cast, no candidate got more than 50% of the votes cast. And so that is the argument of the NDC. Now, the Electoral Commission's lawyer, Justin Amenuvo, now brought the exhibit that Mr. Esiedun Ketia had attached and exhibit in the petition to present it to him to compute and collate the figures to do the deductions and arrive at the conclusion that this was an election that was settled by more than 500,000 votes. He then explains the difference in, because you recall that for Eastern Region, there were two results. There was one summary sheet results that the NDC agent signed, and there was another sheet that the NDC agent didn't sign. We have heard the Electoral Commission explain publicly that a constituency was not included, and so that was the calculation that he was given a calculator to do the deduction. Then he gave the figure that was around 40,000, which Mr. Amenuvo suggested to him that the 40,000 is as a result of the constituency that was excluded. And so that was why he was made to do the calculation, one in relation to that region's results, and the second in relation to the difference in votes between the two main candidates, to show that the election was settled by more than 500,000 votes. And so if the claim is being made that there's vote pardon, then the case will be made that not much changed. Mr. Ediji Tamaklo is just passing by. I'll just quickly engage him briefly. Counsel, thanks for joining us on JoyNews.
Thank you.
First, what is your side's view on this particular video that is supposed to be played on Monday?
No, it does not speak to anything. I think that the respondents, particularly the second respondent, are engaged in their own, case. It's a different matter they are dealing with. At the core of this petition, and look at the issue set. The issue set down for trial. with the very greatest respect to my learned senior Akoto-Ampao, a man I respect so much, he's allowed with respect others to put in something just to look. The respondents are not denying that the instrument of declaration on the 9th of December cannot stand any scrutiny. Admit it. That instrument of declaration. And they are running away from it. It is the instrument of, speak to the instrument of declaration. Why? If you come out and play 10 videos, which one of the videos, with respect, suggests that John Mahama, Asedun Ketia, or any one of them is the Electoral Commission?
So as far as you are concerned, that video is not relevant?
Completely. The constitutional responsibility under Article 63(3) is performed by only one person, the returning officer of the election. Why is John Mahama not the Electoral Commissioner?
But Council, if you have an individual, Council, if you have an individual who has publicly said that this party won the election in media engagements that we covered ourselves, and the person comes in to testify to the court, doesn't it go to the credibility of the issue to put and confront him with those videos?
Nothing to do with it. That's why I said at the core of this petition, it's Article 63(3). Who has the constitutional responsibility? And the court has said 5 issues down for trial. Who has that constitutional responsibility? I mean, so let us not be distracted. The second respondent, with respect, and his lawyers, and my senior Frank Davis, I respect him a lot. But it appears he's rather using this petition hearing for something else rather than advancing the cause of justice.
In terms of the proceedings on Monday, am I to suggest that from your explanation that you oppose its admission as evidence?
For whatever it's worth, when we come on Monday, a determination will be made. The video will first be played. The court will consider of the 5 issues that the court has set. And with respect, you saw, even when my learned senior Akoto-Ampao made the application, their lordship actually pointed out that the basis, the foundation, I mean, had nothing to do with relevance. So at a point, his lordship Justice Nana Mekache had to tell him that, look, address us on the critical issue of relevancy. You heard that? It was at that point that he said, oh, we want to test the credibility of the witness of the petitioner. I mean, issues like, oh, you know, the General Mosquito says he's not the petitioner. In any case, is he the petitioner?
No, he's not.
The man says, you have asked me a question that the knowledge, I don't know what is in his state of, mind at any point in time. What I can speak to is what is within my personal knowledge. Like Mr. T will say, this is elementary. Because you cannot testify as to the state of mind of you. By now, a lot of things are running through your mind. Exactly. So now if I ask, when Blair was interviewing you, do you know why he asked you that question? How am I supposed to know? In any case, we are calling 2 witnesses. Look at some of the things that were being asked.
The second one.
Witness Kwesa White was in the strong room. All throughout the paragraphs of the witness statement of Johnson, I say, nowhere did he say he was in the strong room. And so he kept insisting that if it's about strong room, there will be a second witness who will be coming. And you will be in position to testify, even as to why some of the declaration forms were signed in the strong room. Perfect.
Thank you very much. You heard Ediji Tamaklo there. He's a member of Mr. John Dramani Mahama's legal team, engaging us on the issues that have come up so far. Gifty.
Very interesting conversation you've had with him there, which is a part of the conversation we've already had. But let's take a look at the witness statement and how the whole incident played out in court. Now, out of the 10 that the second respondent lawyers had issues with, 7 of them were removed and 1 was expunged. Help us understand the difference between expunging and removing. Wouldn't they mean the same?
I mean, for the point being made is that, I mean, questions were raised about some of the claims that have been made and the fact that they were not relevant. And so you had just about 3 of them that the court said that it was going to maintain because it held that those are matters that had been pleaded in the petition. And so for the ones that the court considered to be scandalous, that's what the court said, that, I mean, it should be taken off the records completely. And so it will mean that in terms of the records of the court, those matters never even came before it entirely. And it then proceeded to strike out the other ones, which will mean that they will not form part of the evidence that will be before the court. While the others that remain before the court, they will be maintained and will be part of the evidence in the course of this particular trial.
Very long day, Joseph, and we've adjourned to next Monday. What are we to expect? Wrap it up for us.
And so on Monday, the main business will be the video evidence. This is a video that we are told has to do with various officials of the opposition NDC speaking after the December 7 elections and claiming that the NDC had won the election with specific figures. And so that video will be played. Then afterwards, Mr. Akutuampa will continue with his cross-examination. And the indication we are picking is that he will be confronting Mr. Esiedun Ketia with some of the things that have been said to make it a point that he's not a credible witness. Once Mr. Akutuampa finishes with his cross-examination, the lawyers for the petitioner would have the opportunity to do re-examination if the court permits them to do so. Then once that is done, then they can proceed to call their second witness. That will be Dr. Michael Pesa-White, who, as you heard Mr. Esiedun Ketia say today, was one of the representatives of John Dramani Mahama in the Electoral Commission's National Coalition Center, and he will be speaking to those matters that transpired in the Electoral Commission's National Coalition Center. And so this is by way of what to expect on Monday, Gifty, and hopefully it will not be a long day as today was.
I can tell from your voice, Joseph. Well done, and thank you so much for that very comprehensive details that you've shared and continue to share with us. Joseph Akable is our court correspondent. You can expect nothing but the best from his side of things. Well, on Monday, we're back in court. We'll see how it all plays out. Remember, the election petition update is brought to you by, in association with Petrosol. Clean fuel in full quantity is always a delightful experience. And DBS Roofing, we truly are your roof experts. Coa mixture, the immune booster for your general well-being. Now, a little bit more about Petrosol. Due to hard times, we have come to value hunters. But what are we hunting for? Value the right way. Remember that your engine is more valuable than cheap fuel. Be smart and hunt for holistic value is what Petrosol is saying. They say that holistic value is when you have quality fuel at the right quantity and at a fair price. At Petrosol, they serve you clean fuel in full quantity at a fair price, and that is holistic value. So Petrosol wants you to come around and do so. Petrosol clean fuel in full quantity. DBS Color Link, after several years of intensive research, DBS Industries Limited brings you roofing sheets to help complete your dream house in style. Experiencing the amazing touch of Color Link Plus roofing sheets in 26 years, which means Color Link Plus roofing sheets always stays clean and beautiful for you. And there is more. They're giving you a whopping 20 years warranty against fading and peeling. Visit DBS Industries Limited in Accra on the Spinters Road in the DBS building near Papaya Restaurant. Call the hotline 024-084-4444 or 0543 286-637. You can visit their factories in Kumasi, Tamale, Takrade as well. DBS Industries Limited, we truly are your roof experts. And this is still The Pulse with me, Gifty, and